Welcome to We Dissent, the podcast with secular women attorneys discussing religious liberty issues in our federal and state courts and our work to keep religion and government separate. I'm Rebecca Markert with Americans United for Separation of Church and State.
And I'm Liz Cavell with the Freedom from Religion Foundation.
And I'm Alison Gill with American Atheists.
So it's that time of year again. I want to say that it's the time of year that we're always waiting for when the Supreme Court hands down decisions, but I don't want to imply in any way that that's what we're excited about, especially given the last few years. Usually, I love summer. It's my favorite season, but the last couple of years, the month of June is like the worst month ever. And I feel like instead of being a wonderful start to my favorite season, it's always a time where I have a lot of stomach turns and anxiety issues.
It's also LGBTQ Pride Month, June. And we've gotten so many over the last few years, so many bad decisions coming down right at the beginning or end of Pride Month, which is just disgusting, frankly.
Yeah.
Yeah.
It really casts a pallor over summer and Pride, especially with today's radical court, just the feeling of dread as the month goes on and you're waiting for all the big cases.
Well, we're waiting for all of these cases and then they're all horrible and terrifying. And then we have to go and turn around and be like, yay, America, happy 4th of July.
Mm-hmm.
So yes, they all came down at the end of June. Actually, they went into the beginning part of July this year, but in today's episode, we are going to recap some of the key decisions from this past term, especially the ones that are impacting our work to keep religion and government separate. The first two cases are ones that we've already discussed at length on this podcast. We're going to discuss the mifepristone case and the EMTALA case. In fact, those cases were the topics of our last two shows, respectively. But then we're going to shift a little bit and talk about two cases that we haven't previously discussed, but are just as important, relevant, and even more terrifying for our future as a secular nation. Those cases being the Loper case involving the Chevron doctrine, which Alison will talk about in a little bit, and of course, the now infamous Trump immunity case. I'm going to cover briefly the mifepristone case. As a refresher, this is the FDA versus Alliance for Hippocratic Medicine case. As you might recall, the facts of the case were these. In 2000, the Federal Food and Drug Administration approved mifepristone tablets under the name of Mifeprex, and these are used for terminating pregnancies up to 7 weeks. In 2002, 3 pro-life associations submitted a petition requesting the FDA to rescind their approval of the drug, and the FDA denied that request. In 2016, the FDA relaxed some of their restrictions from 2000, finding that Mifeprex was safe to terminate a pregnancy up to 10 weeks rather than just 7. Then we fast forward to 2019 when 2 pro-life medical associations file a petition asking the FDA to withdraw its 2016 modifications to their approval. The FDA again denied this petition. Then in 2022, 4 medical associations and several individual doctors sued the FDA in federal district court in Texas, challenging the lawfulness of the FDA's approval of the drug, and also modifications relaxing the conditions of use. So this was filed in Texas, came before our favorite judge, Judge Kaczmarek, in the Northern District Court of Texas, and he granted the motion for a preliminary injunction and had determined that the plaintiffs had standing, they were likely to succeed on the merits of their claims, and would suffer harm if there was continued approval of the drug. This then bounced back and forth between the Fifth Circuit and the Supreme Court over the injunction, but eventually found itself back before the Supreme Court on the issue of whether the 2016 and 2021 FDA actions approving the drug were lawful. On June 13th, 2024, we did get a opinion from the Supreme Court, which was unanimous.
Unanimous? Credibility restored.
Well, hold on, Liz. Justice Kavanaugh wrote for the unanimous court, and they upheld the FDA's approval of mifepristone, finding that the plaintiffs actually lacked standing to challenge the administrative action.
Yay. Just like we all said.
This is exactly what we said in our previous episode after hearing the oral arguments. But specifically here, the Supreme Court rejected the plaintiff's argument that they had standing just because they had a mere desire to limit other people's access to a medication. That did not equate to an injury sufficient to meet the requirements of standing, which is the legal right to sue. And other arguments, including downstream conscience and economic injuries that were pled by the plaintiffs, were found to be too attenuated to sufficiently assert Article 3 standing.
So we obviously talked all about this deficiency in this lawsuit in our episode on the mifepristone case, right? Which is that the whole premise of the lawsuit was so divorced from an actual effect of the FDA's approval of this drug on the individual suing, which, if you recall, like Rebecca said, the main plaintiff was a association of pro-life doctors, the Alliance for Hippocratic Medicine, that was literally formed like months after Roe versus Wade was overturned, explicitly to start pushing the boundaries further and litigating cases like these. And of course, the lawsuit was filed specifically in that Northern District of Texas to shop for the only judge that sits there who gave them the favorable ruling in this case. So this was a very sort of orchestrated case in order to get the outcome that they wanted. But of course, what the plaintiffs wanted was to take mifepristone off the shelves, not to redress some sort of injury that they were facing as doctors themselves. Because remember, the doctors in this case are not necessarily OBGYNs. They don't prescribe mifepristone. They don't perform abortions. They're anti-abortion medical professionals. So it's good, right, that the justices saw reason and that the opinion was unanimous, even though I'm obviously being flip about their credibility. But this was the appropriate outcome. We could argue about whether or not this case should have been taken at all.
Yeah.
And we will. But this was the only correct outcome. These plaintiffs clearly did not have standing to bring this claim. So, I mean, there's that.
But in some ways, they're also reigning in the Fifth Circuit, right? I mean, it's not just up to the Supreme Court, right? I mean, the problem is the Fifth Circuit just lets this stuff come out of Judge Kaczmarek's courthouse. And they found there was not standing to challenge parts of the rules, but allowed a lot of these challenges to move forward. And now the Supreme Court has clarified, no, there is no standing. Your theory of standing is dumb. That's not, a legal term, but and no, this is not applicable. This is not possible, and it doesn't even meet Article 3 basis for standing. So it's not actually constitutional for us to do this, right? It actually violates the Constitution for us to take this up and look at it, which is helpful as a framing. It means that the court, there's some ability for courts to have a plenary standing, to extend their standing. They cannot do it in this case, which is useful.
Right. Well, I thought it was notable that there were not dissenting opinions or even, because I will say, this is not going to be my on-air apology to Justice Gorsuch, but I did predict some harmful, even in a standing opinion, right? Some harmful dicta or concurring language that was meant to kind of take a shot at quote unquote offended observer standing, right? The basis of standing that we do rely on in Establishment Clause cases, but also environmental cases and cases where the harm that you're trying to substantiate in your case is based on your exposure to some sort of unlawful government conduct, and the harm that visits upon citizens. And so we know that many of the justices on the court are very hostile to that theory of standing and, of course, those claims. And there was some questioning along those lines by Justice Gorsuch at oral arguments. And I did think that there would be some more musings from some of the ultra most conservative justices on those points. And that was absent.
I agree with you, Liz, that I was surprised that Gorsuch didn't go off about offended observer status because I think he probably really wanted to. Mm-hmm. But because we did get a concurrence written by Justice Thomas, who obviously agreed with the majority, saying that the plaintiffs lacked standing, but he would have rejected it under a different theory rather than making this a third-party standing argument. He wanted to remove the doctrine of third-party and associational standing altogether.
Well, that is definitely something that does speak directly to some of the ways that we bring claims on behalf of members of our organizations, right? We do assert associational standing when we are also plaintiffs in cases that we're bringing on behalf of our members. Many organizations do this. This is the way that powerless individuals who are affected by government action or third-party action can bring lawsuits, right? With the help of organizational backing. There are many requirements that make it so that the individuals that are being represented by associational standing must have standing to assert themselves. Yes. So it is wrong, just factually, to equate the mifepristone case as emblematic of the problems with associational standing. I mean, that the problems with these plaintiffs are not the fact that the association can't assert standing because it conflicts with Article 3. The problem with their standing and their association standing is that they have literally nothing to do with the challenged action. It doesn't affect them in any way, shape, or form. So it is, bull crap. It's exactly the kind of thing I expected from Justice Gorsuch on a different track, but by Justice Thomas, and notably kind of writing alone in a concurring opinion that he would have taken the opportunity to do away with association standing, which would have affected us as well.
And this is really a fringe position, as you're saying, but I will point out that, where the court is now, it's now taking many of the fringe positions that Justice Thomas has been laying out for the past, 30 years? You know what I mean? That's where the court is on some of these ridiculous things we're seeing. And, what is his wacky fringe today becomes conservative mainstream through the Federalist Society tomorrow. So it's pretty worrying because without associational standing, unless you're rich, you don't have access to justice, right? So it's pretty concerning. The thing I was going to point out before also was, we discussed a couple weeks ago about whether they would rely upon the fact that there was conscience protections in the law, and therefore that's part of the reason why they don't have standing. And in fact, I think that's what happened. Do you folks agree with me there?
Yep. So you called it, and it was right there in the opinion. They explicitly used the opportunity to say, even in EMTALA, which has its own case that we're going to get to, conscience protections are available. And so there's just one more reason why their claims, even based on they might be made to violate their conscience, are deficient. And I agree with you, Alison, there was literally no reason to go that far. I mean, that, again, their standing is so deficient. There's no reason to say they have these conscience protections built into the law and even EMTALA, so therefore they don't have conscience harm. They don't have conscience harm because they don't have conscience harm. They have no harm, conscience or otherwise. And so I definitely was making a check mark in the margin, point Alison 1, SCOTUS 0, because that was 100% kind of an unnecessary thing to be explicit in the opinion, which is they wanted to, for the record, put it in the opinion that even EMTALA has built-in conscience protections.
Yep.
So that covers mifepristone.
Let's move on because we have a bunch of others to cover,
we have a lot
right?
to cover. And the long and short of it is mifepristone stays approved. It stays on the market. But of course, this was just a dismissal of one lawsuit on a really deficient lawsuit on standing grounds. there's not going to be any shortage of new challenges with probably better plaintiffs to mifepristone in different ways. So
Yeah.
Yeah, do not think that they're going to stop and think, okay, well, we lost. I think they're definitely going to be back in some way, shape, or form.
all right. Well, speaking of EMTALA, we teased it, and we'll cover that case next. So if you remember, we didn't profile it in a standalone episode, but we've talked a lot around it. The Supreme Court was considering this case out of the state of Idaho that involves this federal statute, EMTALA, the Emergency Medical Treatment and Labor Act, which we all call EMTALA. It's a federal law that's been on the books for a long time. The reason why this lawsuit came to be is because after the fall of Roe versus Wade, Idaho passed one of the nation's most restrictive abortion bans. The only exception it has built into the law is to save the life of the mother, unlike some abortion bans that provide for saving or preserving the life and health of the mother. And that's an important distinction because this law, EMTALA, is a federal law that requires all hospitals that receive federal funding, which is essentially all hospitals because of Medicare and Medicaid funds. Anyone that comes to them for emergency care must be given stabilizing care. That seems non-controversial, but it was something that was seen as needed, I think, in the 80s, right, to prevent hospitals from transferring patients who couldn't afford to pay or who were uninsured. But now, because there are states that make it against the law to provide an abortion, even to preserve the health of the mother, there's a potential conflict of laws. And that's been playing out in the state of Idaho, where emergency room doctors are afraid to give abortion care even when it's necessary to stabilize a pregnant patient because they're worried that they might be prosecuted under Idaho law. So the Biden administration sued the state of Idaho in order to argue and get the courts to agree that EMTALA preempts the Idaho abortion ban whenever it conflicts in any given situation. In the district court in Idaho, the court agreed with the Biden administration that EMTALA preempted Idaho's abortion ban. And that court granted a preliminary injunction saying that basically the abortion ban can't be enforced when it conflicts with EMTALA in an emergency room setting where a patient needs to be stabilized with abortion care. The Ninth Circuit declined to stay that injunction. And Idaho, with an emergency on their hands because they can't kill women in the emergency room, filed an emergency petition for cert with the Supreme Court. And the Supreme Court agreed to take this case back in January, and it allowed Idaho's abortion ban to go into effect while the case was pending. In other words, they stayed that injunction, preventing the abortion ban from going into effect where it conflicts with EMTALA. So fast forward to June, and the court decided in a 6-3 opinion that review of this case was improvidently granted. In other words, oops, our bad. We shouldn't have granted review of this case, so we're just going to vacate the stay that we issued and dismiss the writ of cert. So it goes back to the district court's preliminary injunction going back into effect. In other words, back to what the district court decided originally, preventing Idaho from enforcing its ban when abortion care is needed to stabilize a patient. And literally, we're right back where we started before the Supreme Court decided to intervene. This case goes back to the district court to be fully briefed.
This is, just so folks know, called digging or digged, the dismissed as improvidently granted. And it happens from the Supreme Court from time to time because there's, you need 4 justices in the Supreme Court to agree to pick up a case and grant cert, right? And then maybe they couldn't agree on an outcome, or they decided that it wasn't like something that they needed to be, the case was not right for a decision, or they want to see how it develops further in the lower court. There's a lot of reasons, but this was not something that they could arrive at an opinion around. So it was dismissed as improvidently granted or digged.
Yeah, it was definitely not unusual, but unexpected. I don't think any of us predicted necessarily a dig outcome in this case.
No, I thought we were in trouble. Yeah.
Yeah. So in that sense, I guess it's good. The court didn't do anything harmful in terms of its interpretation or preemption doctrine. It didn't do anything harmful on the merits. But I do think there was some like major just nightmare reading in the dissent that is worth talking about because, of course, it was a 6-3 opinion. 3 justices joined Justice Alito in dissent, and he was just his usual absolutely obsessed anti-abortion activist fetal personhood ideology. He would have obviously reached the merits, found in favor of Idaho. His dissent is that actually EMTALA explicitly protects unborn children. He's quoting a part of the statute that references pregnant woman and an unborn child. And he basically uses that language to, in his reading, like infuse EMTALA with this fetal personhood protection that he sees as an unambiguous part of EMTALA and rejects that the individual pregnant person can demand any kind of stabilizing care that would like impinge on that right of the, in his words, unborn child. So it's a pretty extreme idea of how to rule on the merits, but I guess not surprising, and joined by 2 other justices. So I found that very scary.
I found it very scary that the Supreme Court refused to find federal law to be supreme. It's just, that question still exists. That conflict is still there between the state law and EMTALA.
Right. So see also the concurrence written by Justice Jackson, who agrees with you and thinks that the court should have ruled on the merits that, yes, EMTALA does preempt state law if it conflicts, and anyone in Idaho or anywhere else in a federally funded hospital who is pregnant and needs abortion care to stabilize their condition should absolutely 100% get it and not be able to be prosecuted under state law if there is such a state law. And that would have been the holding of Justice Jackson, who did concur in the vacated remand, but did not agree that they didn't need to reach the merits.
I mean, this could certainly come back to the court too. I mean, it's going back to this is a preliminary matter. It's going back to the court for the full consideration. And this is an issue which we are likely to see again as there's more conflicts between state and federal law. Right.
And again, it goes back to the status quo. And we know, because we heard it in briefing and oral arguments, that the situation on the ground in Idaho and places with similar restrictive bans is that any doctor who back in January in Idaho didn't feel safe giving stabilizing care that involves an abortion isn't going to feel any better about that after this opinion, right? There's nothing in this opinion that gives any kind of direction or safe harbor under EMTALA to any providers who are treating patients in states with laws like Idaho, and Idaho is not the only one, unfortunately. So again, this is not an issue that's going away. It's just going back to the lower courts to pick up right where it left off in January. So cool use of time by our Supreme Court.
But also just a reminder of how much like they don't care about women with the state of maternal health and maternal deaths in this country, that they wouldn't come forward and say EMTALA reigns supreme because patients who show up in the emergency room deserve basic health care that will preserve their life and their health, is so infuriating and upsetting to me. It's what I was thinking about when I was reading these decisions. Again, like the attacks on women are not done. And while the status quo is maintained for now, it's still not good enough.
No, the status quo sucks.
The status quo sucks. And it, like we've been saying, it's not over. It's just been temporarily paused. And we are going to see these cases come before the Supreme Court again. The people who brought these cases to begin with aren't going to see it as a complete loss, and they are going to continue this fight until they get the court to actually take the case, perhaps decide on its merits, perhaps in a non-election year.
Yeah, I was about to say, let's bring some real politics into this, right?
Right.
I mean, if they had decided that EMTALA didn't apply, that would be all over the newspapers. It would be make a really big splash, and it'd be all about the Supreme Court once again reining in access to abortion, and it would have been really negative. And if Trump were to win the election as in charge of the DOJ, they could just kill this case quietly. They could just say, okay, well, we're dropping this. Idaho, go back to killing women. That's fine. And they can just do that, right? That's what'll happen. And I don't think people sometimes realize that when we're voting on a presidential election, we're also voting on enforcement of our laws, right? That's a major part of it. And I'm going to talk about enforcement in the next section.
Well, I do think it's important, right? We're transitioning to some other cases that go broader than these abortion cases. We thought it was really important to cover a couple other cases because this term definitely deserves a more broader context type discussion in terms of the harm that was done. And because I think the cases involving abortion that we did cover in our past episodes definitely gave an incomplete picture of what the court did this term and along what lines and what the broader impact was. So I think it's important as we're covering a couple of these other opinions that were really huge and are going to fundamentally change the way that we operate on the issues we care about, but just secularism, democracy, and power. And of course, the issue we talk about all the time, which is the power of the court.
And the very functioning of our government. I mean, these are fundamental changes to how our government functions. So we've talked about some of the cases that turned out well, or as well as can be expected from this court. Now let's go into some of the ones that maybe didn't turn out as well. That's putting it mildly. The first is Loper Bright Enterprises v. Raimundo. This is a case having to do with the Chevron doctrine. So this is really a case about whose interpretation of law matters when a statute is ambiguous. Is it the agency responsible for administering the statute or the courts? Who is the expert here that typically gets to define how the law works? And under the Chevron doctrine, which is basically a court-made law from the 80s, the courts are typically must defer to permissible constructions of the agencies when Congress does not speak clearly on an issue through statute. So if there's an ambiguous question in a statute, the agency's interpretation, as long as it's reasonable, the court should defer to that. So it's really a two-step process. Did Congress address a specific issue at hand? And if not, and there's some ambiguity, is the agency interpretation based on a permissible construction of the statute? Is it possible to read the statute this way, basically, right? And if so, deference is granted. Deference means unless there's some compelling reason otherwise, the court will just sort of agree with the agency's interpretation. I feel like the facts of this case are almost unimportant. It deals with a program created by the National Marine Fisheries Services to assess the health of fisheries and determine if they're being overfished. The statute says the agency may send observers on ships, like fishing vessels, but the question is whether they can impose a fee on the fishing companies to enable this, and that's not spelled out in the statute. And that's not atypical, right? It's not spelled out for certain types of fish. It is for other types of fish. I think.
Hang on a minute. What does Brett Kavanaugh think about this question?
It's pretty crazy. Okay, so the majority basically says that relying on three different arguments, they overruled the Chevron deference precedent. So this is, again, precedent from the 80s about how the government functions. They say Article 3 of the Constitution grants courts, Article 3 courts, like district courts, Supreme Court, all the different courts, a federal court system, the sole authority to adjudicate cases and controversies. And therefore, they cannot defer to agencies or they're failing in their duty. They have to decide things themselves. They can't defer to agencies. Second, based on the language of the APA, or Administrative Procedures Act, which is the act which defines how regulations are made, courts are required to decide, quote unquote, all relevant questions of law, and deferral to an agency denies that, which is a stretch if I've ever heard one.
Right.
And then 3, they say Chevron is inconsistent, doesn't make sense, leads to conflicting outcomes. It doesn't result in the stability that the courts thought it would. It misconstrues congressional intent. And courts are actually experts, not agencies. Courts are better able to do this than those pesky experts, right? So that's sort of the outline of the argument. So there's structural arguments based on the Constitution, statutory arguments based on Administrative Procedures Act, and then just policy and other sorts of arguments around these issues. But why is this important, I think, is a critical question you might be asking. Why does this matter? I talked about this in a previous episode on regulations, which is an excellent episode. You should definitely check out. Regulations are fascinating. Regulations are how the government works, how the government functions. I mean, Congress passes statutes which on their face don't do anything, and they're often very, very broad, right? Someone has to make those statutes actually do something, and that's generally agencies. So they fill in the gaps, they implement them, they put out guidance, they enforce them, they have enforcement attributes. These are all things that Congress might spell out and might not. And let me give you an example. Maybe under the Clean Water Act, for example, Congress can prohibit contaminants in the water. But Congress can't go through and list every possible contaminant because companies invent new things to pollute with every day, right? And Congress doesn't know like what parts per million is dangerous or what these new chemicals are. They just can't legislate with that kind of reactivity. But agencies are able to do that assessment in an informed way. So if Congress is able to sort of lay out the scaffolds, right, then the agency should be able to fill in the details. But this decision will let courts second guess everything the agency does, which makes it really challenging for agencies to be able to lay out consistent rules, right? It makes it very, very challenging. Agencies are better able to use their expertise and to get input from the public through the public comment process than courts are. If you think about court processes, they're adversarial against one party, against maybe the agency and the government. But like everybody else who relies on us actually having fish, let's say in this instant, that they actually don't get overfished and and we actually continue to have a food supply in the future. Everybody else have no say. It's just these one litigants in the agency. But if we're talking about them making regulations, then everybody can have public input into the regulatory process. So agencies are better able to work in that method, and they're more responsive to public will than courts are. Because once a court decides something, we're out of luck, really, which is another issue. They're anti-democratic, right? Especially where we are in the courts these days. It's very clear that they're anti-democratic. But agencies, they'll change based on who's president. They'll change based on public pressure. There's a lot of different factors which courts are just not subject to. This is being portrayed, this case, as one which is, well, we're just granting the power from the agencies back to Congress, a lot of people say. But they're not. They're doing the opposite of that. Because the thought process is here, well, if the agencies aren't defining the rules, that just means that Congress will have to do it themselves. But what's really going on is a power grab by the courts. And it actually undermines Congress because Congress, the way this works is Congress has to make laws, but the Chevron doctrine steps in whenever there's ambiguity in the law. And I'll tell you, courts can always find ambiguity in a statute, right? They can always find it. There's no way for, in the instance I just gave with the Clean Water Act, for them to be able to spell it out in a way that insulates like the EPA or whatever from court intervention. So it actually gives the courts more power. It makes it more difficult for Congress to write laws. So I'll stop there and see what thoughts you have, Rebecca and Liz.
Well, and it just gives more incentives for special interests to bring those lawsuits to challenge agency action that they don't like, because now the courts have signaled to them, we're not going to give any deference to what agencies are doing, and we're going to revisit any and every decision that's made by agencies. So if you don't like what EPA regulation just happened and you're a polluter, come take your chances in the federal courts and see if we're more friendly to your interests. Whereas Chevron deference was setting up a stabilizing influence for agencies to do their work, not thinking that it's as easy as finding the right federal judge to undo all of their agency action. Like, right, it's going to be an uphill battle for people that want to say, undermine the FDA, the FDA's approval of abortion drugs, or do whatever, undermine any agency action. And there's so many, right? It's the FDA, it's the fisheries, the EPA, it's the Department of Education, it's NPS,
HHS,
it's all exactly. It's like Alison said, it can't be overstated how much we rely on federal agencies to literally make everything in our lives function and give effect to everything that our representatives are doing on our behalf. And so, again, the biggest takeaway of this is this Supreme Court is, again, grabbing more power for itself, consolidating more of the decision-making authority for itself, taking it away from the people, Congress. Because, by the way, Congress is part of this delegation to agencies. Like
Yes.
This is not something that some court decided in the 80s and Congress is like, we want our power back. No, Congress understands that they can't function without delegating this rulemaking authority to agencies because they don't have the ability to act with that level of specificity, like Alison was saying, and that level of subject matter expertise, or even just it needs to be reactive and it needs to be something that can respond to changes that happen in the field in the future. Every law is not just a static thing that Congress only has to act once, right? Agencies need to be able to put laws into practice and have the freedom to make changes and update regulations to respond to the real world. And the court is just taking all of that power away, which is what our representatives have delegated to agencies, and saying, nope, we're actually going to take that power. And also, we're not accountable to you people in any way, shape, or form.
Yeah. It also just goes to their whole egotistical, we know what's best for everyone.
Right. Now, not only are they historians.
Exactly. I was
just
they're fisheries experts.
Like, we know history, we know science, we know medicine, we know everything. And we don't need to defer to experts on anything.
Are you calling lawyers arrogant? Seriously?
I might be, you know.
It's crazy. It is crazy.
But it is terrifying. And as we've been discussing all of these cases, and we're only on the third one, my stomach hurts. I feel like the status quo sucks, but also I think it's because the status quo is just uncertainty about what the law is, where we're going, and what our general health in all manners is going to be eventually. So it's really upsetting. But I do want to also point out something that's a little bit of a light, and that is we are not a podcast that has video attached to us. We're audio only. But if we did have video, which we don't want to have because, you know, the internet is just mean to women. And so I just don't want to do that to us. But if we were to have video, I think everybody would have seen how amazing Alison was talking about the Chevron doctrine. She had this just like glow and light about her. Like, you were so excited about it. And I'm not sure that I've seen anybody that excited to talk about the Chevron doctrine since my administrative law professor.
Yeah.
Let's talk about
I like
Chevron.
admin law. It's one of my favorite topics. Yeah, I'm a big fan. But now it's totally upended. I mean, they've totally changed the way. Actually, that leads us really well into a couple honorable mentions that I want to give here.
Yeah.
Let's call them dishonorable mentions, actually.
Uh-huh.
The first is Securities and Exchange Commission v. Jarkessi. These are both decisions from this term as well. So here, I won't go into great detail, but it was basically the SEC brought a civil action against Jarkessi for a fine, or I don't have the details in front of me. But regardless, the question was, is this allowable, or does this have to go before a jury? Because under the Seventh Amendment to the Constitution, people are guaranteed the right to a jury trial, right? So there's been created by Congress a whole system of what's called Article I courts. So these are not Article III based under the Supreme Court. They're Article I based under the administrative bureaucracy. And they have what's called administrative law judges, or ALJs. And so the question that they brought up in this case is basically, well, can you impose SEC fines on us without having a jury trial by just having us appear in front of this administrative law judge? And basically the court said, well, if it's anything that's similar to an action at common law, which is going back to the original understanding of the Seventh Amendment. Basically, we're thinking about common law, like what the law was at the time and how it was understood. So this was an action around fraud, which is a well-known concept in common law. So if this civil penalty has anything to do with or similar to an action at common law, then no, you have to go to an Article 3 court and you have to allow for jury trial, which means we have a whole system of enforcement built up where agencies can bring claims and that are heard by administrative law judges, right? And then the administrative law judges are experts in the field. They're able to do quick and easy and fair, but basically to basically bring judgments without having a prolonged court battle over things, which is much slower and much more expensive. We only have 850 district court judges in the country, something like that. So it can just imagine how many enforcement claims go through ALJs. We have hundreds or thousands of ALJs. And so this ruling means basically it just guts the system of using ALJs. It means basically if agencies want to enforce anything that's analogous to something in common law, they have to go to the courts. They have to go to Article 3 courts, which means it's going to be way more expensive. They aren't built for it. The DOJ is going to be under a lot of strain. What it does is it prevents enforcement of our laws wholesale because it slows them down to make it impossible when there's, I don't know, people violating securities and exchange law, voting law, pollutant law, fishing law. I mean, anything makes it very, very challenging for the government to actually enforce things. So it's a huge gutting of people's liability under the law. And then the other one worth mentioning here is Corner Post v. Federal Reserve, which under the Administrative Procedures Act or the APA, there's a 6-year window where people can bring challenges saying, well, this rule doesn't follow the APA and therefore we're going to attack it, a rule that an agency passes. And here, basically, the court says, well, that's fine if you're a newly regulated entity. Let's say I don't know, we're talking about fisheries a lot today. So let's say you have a new fishing vessel and you're just entering the industry and you don't like this rule that was passed 20 years ago, but under the APA, it'd normally be out of bounds because past 20 years ago, the statute of limitations has run, but you're newly in the industry. The court says, well, you know what? You get another 6 years from when you begin to get regulated. Which means
we just invent a statute of limitations.
Yeah, under the APA, they just reconstrued the APA to basically grant this 6 years, and that means it opens up the number of challenges to any regulation anytime, because basically you can always have new people enter and be the system and become regulated. So we talked about how there's no deference granted under the Loper-Bright decision under Chevron. Here, this just massively opens up every single rule to re-challenge in any court. It's just such a huge shift. And altogether, you can see how this completely shifts power to the courts and just guts the administrative state. And also opens it up very, very easily to things like Project 2025. So it's quite concerning, and it's just a massive shift in how the government is going to have to function in this new paradigm.
Can you just talk about how Congress can act then? Like if they're just making up statutes of limitation, is there any way that Congress can come back and say, no?
They could. The Congress could look at the APA and say, well, that's not how we actually meant it. I mean, this is not a constitutional ruling. It's a statutory interpretation ruling. The Loper-Bright decision, they based it on both Constitution and APA. But here, for this, the statute of limitations, that's purely statutory. They could just look at APA and say, okay, we're going to clarify. We mean from when the rule becomes final. We don't mean every single random person when they begin to get regulated gets another 6 years to bring an action, because that's crazy.
Because, of course, it's not that hard to start a business or an organization.
Yeah.
Just ask the Alliance for Hippocratic Medicine. Like, right. If you want to file a lawsuit, but you need a business in the industry to do so, it's actually not that hard to do, right? This is just a roadmap for how to undermine regulations that you don't like. And the Supreme Court giving their wave and nod that we'll be the ones to decide whether or not a regulation is reasonable and appropriate. Don't worry, it's not going to be some tree huggers at the EPA. It's going to be us. You cannot overstate the impact of those three decisions that Alison just described on the remaking of American law and life.
Yeah. Agree. So we don't know what the outcome's going to be here.
You might think that must be all.
Yeah, well, we don't know what the outcome's going to be here ultimately. I mean, this is a whole new paradigm, as I said, for agencies. And I think, it's going to require a lot more funding for them, frankly, so they can actually bring enforcement challenges, because they're already strapped for enforcement in almost every agency, because Congress doesn't like to actually fund enforcement because their donors are the ones facing enforcement and they don't like that. So, but now it cuts it way down. So you can imagine the problems there. And the last case, which is by far the most worrisome to me after all that terrible stuff, is Trump v. US, which is about former president subject to criminal liability for his actions while in office. And it specifically is about Trump's actions to obstruct or overturn the 2020 election. And here, he claimed he has immunity to criminal prosecution for actions taken as a part of his official duties. Most people, I think, thought the court would say, that is ridiculous. You're not a king. We're going to throw this out. And they just a delaying tactic. You know what I mean? I thought that. What did you both think?
Yeah, I thought, I didn't think it would be like this robust of a ruling on the merits. I didn't think they would set up a whole new framework, a whole new court-made analysis for what acts get absolute immunity. I thought it would be a much more narrow kind of disposing of the claims that Trump himself is making in this specific instance, but it was none of that.
I mean, I feel like they were going to hand him a win because, you know, he appointed a lot of them. So I wasn't completely surprised to see what the outcome was. I wish it would have been different.
Yeah.
But I kind of feel that, yep, that was coming.
Well, I'm glad you weren't surprised, but I certainly was by this. And it's the worst kind of surprise. The court did not throw it out. In a truly terrifying opinion, the court distinguished between different types of actions, saying where there's absolute immunity. Let me repeat that. Absolute immunity when the president is acting within his areas of constitutional authority. We'll get to that in a second. There's presumptive immunity for all official actions. All official actions. And there's no immunity for unofficial acts. And I'll put a little caveat on that one because we're going to get to it. And here, and I think the court is right that some level of immunity must exist, right? If a president arranges for an attack in a foreign country, let's say a drone strike or whatever, and, you know, it's technically against our criminal law, but there's nothing corrupt about it. They're just acting as their role as a military chief. Then we can't have people second guess that and sort of subject them to criminality after they get out of. I mean, I understand that. I think that's a reasonable interpretation to hold, right? But we are so far beyond that because here we're talking about any use of official power, like pardons. Like if a person says, President Trump, I will pay you $5 million for a pardon. And he says, cool, that's fine. I mean, even if it's vocally like in the media, it's perfectly fine. Use of military power. I'm just trying to think what else is in the constitutional.
I just want to point out, Alison, that even casual court watchers might have read or heard when this came up at oral arguments. The big hypo was, could the president order SEAL Team 6 to go kill his political rival and be immune? And literally that was seen as like crazy. And Trump's lawyer was kind of like, well, maybe, yeah, probably. Even it was thought that even the conservative majority like balked at that. The reality of this opinion is that kind of, that is because SEAL Team 6 is part of the military and military is your purview under the Constitution. It's a constitutional act and you are absolutely immune from criminal prosecution. That is bonkers.
Yeah. And for all official acts, there's this presumptive immunity. There's not much clarity on how to rebut this presumption of immunity. Basically, the government would have to prove that it doesn't interfere with the president's duties in any way to sort of rebut it in that instance. And that's very, very nebulous, frankly. And also, and this matters a lot for the third section too, the things that are not official duties, they say that you can't look at motive of any action to say whether a duty was corrupt or, look at the motivation. So you can't look at any official activities. You can't look at motive of activities, that sort of thing, to say whether there is corruption or there's a problem, even for unofficial roles. So in the former President Trump's case, he did some official duties like communicating to people, let's say, speaking to the Attorney General, speaking to former Vice President Pence. Those are all part of his official duties, but then maybe planning things like calling up lawmakers in Georgia or whatever to sort of threaten them. Maybe you could make an argument, maybe that's unofficial. But if you're trying to weave together a story and show motivation, you can't use the former to prove the latter because they are official duties. Does that make sense? So it basically makes it, even if you do have this sort of sliver of things that might be possible, if somehow they're not part of his duties and not official, which is so widespread, it's hard to even realize that could be a thing. Even if you did find something that was clearly unofficial, you couldn't rely upon other actions that he did that might connect with his official duties, which I don't know how Jack Smith could possibly bring this case forward at this stage. It's just not possible.
And that tortures just common sense, right? Because the whole idea of what makes something unofficial, if you're the president, involves some sort of analysis or consideration of what's motivating your conduct. It's like, well, I'm the president and a part of my duties is using the phone. So anytime I use the phone, it's an official act. You know what I mean? But literally, that's almost the level of stupidity and just illogic reasoning of this opinion. It truly is, like Nixon said, if the president does it, it's legal. It's like
that is the case now.
That is literally the law.
And it's the worst thing. There's no legal justification for this. None. This is entirely based on policy arguments. I think they read this one passage from the Federalist Papers, and not all the passages that say, "Oh, the president is not a king." They don't read any of that stuff. They read all this subject to the law. No, that stuff doesn't matter. There's one thing that we don't want: a weak presidency. We want a presidency that's bold, and therefore, to be bold, you have to have complete immunity, and that's why we have complete immunity. It doesn't. It's just like this crazy extension, not based in any of our history or background of the founders or any of their writings. It's just invented full cloth here. And we're speaking about what could Congress do about these things. This is, they're sort of inventing this full cloth from the structure of our government implied from the Constitution.
And guess who gets to decide what's an official act and an unofficial act?
Could it be the courts?
9 guesses. It's the court.
Yeah.
So again, the people are powerless. Again, they decide on who's accountable to whom, and it's not the people, it's the court.
Right.
Well, this also just plays into all of Trump's crazy delusions. Like when he was like, hey, I did declassify those documents. I just did it in my mind. Therefore, it's an official act and within his purview. Totally fine. Or I could go down to Fifth Avenue and shoot someone and no one can touch me. Literally, you just handed him all of his delusional reality and said, yep, that's 100% correct.
I mean, he could go seize all the ballots from all the states, and under federal law, he could direct the Department of Justice to just prosecute political enemies.
It's not a crime. It's just going to have to be sorted out through the political process, which is funny given the hypo you just posited.
Yeah.
It is. It's so bizarre. And then for a court that's hell-bent on history to ignore our founding fathers saying the president's not a king, we reject that type of system of government. They're completely ignoring that because they're a court that is completely outcome driven, not based on any legal reason or historical reason or anything. They just want to get to the results that they've already predetermined.
The important part is that there's no accountability. They're going to be the ones to interpret how this doctrine applies to individual presidents. So, if you trust the court to be nonpartisan in how it applies this doctrine to individual presidents of different parties, then I forget what the saying is. I've got something to sell you or whatever.
Yeah, exactly. Yeah.
The broader context of this term that I think was sort of hidden in just a discussion of like the abortion cases is this court continues to consolidate so much power for itself, and that power comes at the expense of people power because the court is so undemocratic. And we see this throughout the term and over the years. They are not responsive to Congress. They refuse oversight. They will not subject themselves to an ethics code that's actually enforceable or oversight by any other branch of government. And at the same time, as they are refusing all accountability to the people, they are grabbing more and more power for themselves and remaking completely what American law and life looks like. It is just absolutely intolerable.
Yeah, I agree. I don't even thinking about like what law professors must be going through right now when they're about to start for the fall semester with admin law. How do you teach admin law after these cases? How do you teach constitutional law? It's just some massive changes. And I don't even know how agencies are going to adapt. It's going to be a real significant change, either with the next Biden administration or a Trump administration. They're just going to have a lot of opportunities to really reshape the face of the law.
And I mean, if we've said it once, we've said it a million times. But like Alison's saying, there's not an easy congressional response to this damage. This is not like a checks and balances. Right. This is court reform is the only way out of this mess. We've seen this court will not cooperate or subject itself to any reforms or accountability. That is the only thing that our people's representatives can do to rein in what this court is doing. And it's not small.
I think I just saw that they were drawing up impeachment orders for Thomas. So that is another avenue, but who knows if that will actually happen, right?
Yeah.
The only avenue that exists that elected officials have shown no appetite for is impeachment of individual judges. But the problem is bigger than that.
Well, there's also apparently SEAL Team 6 now, so that's
exactly.
an option too.
That is an option.
That's an option. But I wanna get us back because we did kind of like shift gears in the latter part of the show to talk about these two cases we hadn't previously talked about, and I think people listening to our show were probably aware of, appalled by as well, but I want to make the connection between the work that we do to keep church and state separate and these two cases. Mm-hmm. What is the connection? Why are we ranting about what the court did here?
Well, there's a few different areas. I mean, a lot of regulations have to do with how these agencies comply with the requirements under the Constitution, including the First Amendment, right? And also they regulate the entities that must comply. I'm thinking about all the rules that we care about. Section 1557 of the Affordable Care Act, faith-based social services have guidelines laid out about how grantees have to follow the law. They can't deny people, for example, benefits based on their religious beliefs. That's a good example, right? And that was a doctrine that was developed by the agency, and it was based on the Constitution. It's not based on a statute anywhere. It's based on an ambiguous issue of law. And now that can be sort of challenged anew. So there's a lot of interactions between religion and government that are administered through the agencies. So this has a real opportunity, unfortunately, for those to be re-challenged in increasingly ideologically biased courts. That's a short answer.
Yeah, 100%. You can't see me again because we are not a video podcast, but I was nodding continuously during that. Yes, during that answer. And that's exactly the connection that I wanted to highlight for our listeners.
And again, it's a way of manipulating the power that exists to effectuate a ideological mission, right? Like Alison talked earlier about how this is paving the way for a new administration to implement Project 2025 through all of the administrative agencies that exist and know that the courts are the only ones that can check them and the courts are in their pocket. So this whole Christian nationalist political ideology in all the ways it exists, right? The Department of Education can be run by Ryan Walters and Bibles in all the schools, and let's put it into federal regulations and not worry about it because now we don't have to answer to subject matter experts, no ALJs. All we need is the stamp of approval of this bought and paid for Supreme Court.
the president can declare this to be a Christian nation.
Right. I mean, it's about power and consolidating that power. And then what is the ideology that's going to be put into place once that power is consolidated? And that's what's scary.
Well, that was a fun way to wrap the episode.
That was. Summer.
Yeah. There's interesting cases coming down the road, too, involving a lot of issues. I have my eye on the Skermeti case, for example, which I'm sure we'll talk about in the future. But yeah, we're going to have to just see how these play out, frankly. And I hope there are some things that Congress really thinks about, like amending the APA slightly to deal with some of this.
Yeah, I think at the beginning of the year, we probably in one of the episodes talked about how the court's not really taking a lot of religious liberty cases. So it seems a little quieter for our organizations. Of course, that was not true, as we've, I think, demonstrated. But along those same lines, because they haven't taken any religious liberty cases, part of that is because after 2022, when they disrupted everything, a lot of the cases that we're probably going to be seeing are still wending their way through the courts. And so next term and the term after that, I think, are going to be another banner year for religious liberty cases. There's more to come, unfortunately, and I wish that we had a way to end this episode with some hope and not end on such a dreary note, but unfortunately, it's just where we are. It was a very depressing, upsetting, and terrifying term.
We'll bring the hope next episode.
Next month.
We'll bring the hope next month.
We'll figure something out.
We're going to get some beach time in and we'll be fine and all.
Rebecca, we live in Wisconsin.
I know. Yeah. Anyway, that is it for today's episode. I'm Rebecca Markert.
I'm Alison Gill.
And I'm Liz Cavell. If you haven't already, please follow us on our socials, Facebook, Instagram, and X. Please also remember to let us know how you're liking the show by leaving us a review. You can also find us at we-dissent.org. Thanks for listening.
We Dissent is a joint production of the Freedom from Religion Foundation, American Atheists, and Americans United for Separation of Church and State. It is hosted by attorneys Liz Cavell, Alison Gill, and me, Rebecca Markert. Production support comes from Greta Martins and AU's summer law clerk, Jillian Snaman. Audio engineering provided by Audio for the Arts based in Madison, Wisconsin. Thanks for listening.